Welcome back. You're watching KTN News and thank you for staying. Special program all to do with the Economic Crimes Act 2003, the Anti-Corruption and Economic Crimes Act. The two laws, two proposals in Parliament right now that are touching on this particular law that has been touted as the legislative strength behind the fight against corruption. So we're just having a conversation around these two proposals. Are they negating the fight against corruption as is? I'm currently joined in studio by Dr. Constance Gikonyo, who's a senior lecturer at the University of Nairobi Faculty of Law, and equally Ben Murray, who's the Deputy Director, Legal Services at the Ethics and Anti-Corruption Commission. We've just reviewed two of those laws briefly and extensively. The first one, proposed by Homa Bay Member of Parliament Peter Kaluma, seeking to repeal Section 64 of the Anti-Corruption and Economic Crimes Act. According to our panelists, this will have far-reaching ramifications in terms of, not prohibiting those corrupt convicts from appointment to office. As it is right now, there's a 10-year period, but if this proposal sails through, that 10-year period will be removed. According to the panelists, this is definitely diluting the fight against corruption. On the other side, we equally have a proposal by the Mbere North Member of Parliament, Geoffrey Ruku, seeking to amend Section 45(2)(b) and (c) of the anti-corruption law. He seeks to substitute criminal prosecution for corruption offences arising from procurement flaws with administrative sanctions. And mind you, as it is right now, almost over 80% of corruption-related offenses are procurement-related. So this is definitely a cause of concern. And right before the break, we were deliberating on the far-reaching ramifications it might have to the law as is. So let's continue with the conversation. Dr. Gikonyo, right before the break, we were deliberating on the negative effect this law has. But in terms of the proposal by one of the members of Parliament, he seeks to seek an alternative route in terms of criminal prosecution for those corruption offenses that are arising from procurement flaws. They want to take the administrative sanctions route. So perhaps there's you'll be paying for your sins, but it'd be through a different way. What exactly does administrative sanctions mean, and is it a lighter punishment, if so to speak?
Ben, I'll use your words. I think, in my view, that administrative sanctions are a lighter form of punishment, because, for one, we have not taken you through we may not, in all of them, have to take you through the rigorous court process. So some of these things may never even come to light. The public may never get to know, which is wrong in this fight against corruption. There is the other aspect of the ramifications that you may not pay as you should because no record is kept. To illustrate this point, let me give the example that for those of us who have applied for a visa to various countries, one of the key questions is, have you been convicted of a criminal offense? Which therefore means if you have been convicted of an administrative offense, you do not need to indicate that in that application form. And which means that the foreign jurisdiction that you seek to go to in evaluating your application will not take that into consideration. But if it's a criminal offense, you are obligated to indicate it. And they will take that into consideration in either accepting or rejecting your application. And which therefore means this person who has engaged in corrupt activities and been gone through an administrative process and been cleared or found guilty will need not indicate that in this visa form. So it means this person is still free to travel anywhere in the globe as a dignified person. Why should we let that to happen? So those are but just some. There are also constitutional issues which my colleague will touch on. So we need to speak out more loudly, and criminal sanctions are louder than administrative sanctions.
Yeah, in the spirit of naming and shaming as well. So as we come to the spirit of the Constitution, and I mean, in a democracy such as Kenya, you know, the rule of law is sacrosanct. So in the fight against corruption, in some of these proposals that we're seeing, what exactly about the spirit and the letter of the Constitution should Kenyans know that in these two proposals sail through, then the red flag is here and in this article? So kindly break it down for us.
So the makers of our Constitution intended it to have substantive bite, not just have wish list, you know, as they say, a toothless bulldog.
Yeah.
So they created articles of the Constitution and then said, go ahead and create acts to enforce those provisions.
Mm-hmm.
I will tell you that administrative action will not happen because of our experiences, okay? Because even when we charge people, you know, now nobody stops public heads from taking administrative action. But even when we charge people and they are supposed to step aside, and you go to the institution and tell the governor, please, this person of yours, we have charged him, please, section 62 says he must step aside. You hear he's reluctant. You hear one month later he's still earning a salary and still in office.
Mm-hmm.
So the practice is administrative action rarely happens because the eating is institutionalized. It goes up all the way. Only that the signatories are the middle level people, but the big man there is having a share,
okay,
and most likely will not get charged because he has not signed anywhere. Now, let me tell you why I think this proposed amendments goes against the Constitution. Now, and there are two provisions on the site, Article 201 and Article 227.
Mm-hmm.
Article 201 is on principles of public finance. The Constitution is telling us how public finance should be dealt with, okay? And I will mention two provisions at 201D and A, D, and E, three provisions.
Okay.
It says principles of public finance. The following principles shall guide all aspects of public finance in the Republic. A, there shall be openness and accountability. Openness and accountability, including public participation in financial matters.
Mm-hmm.
Now, the accountability bit is going to be diminished. It's going to be hidden somewhere called administrative action. D, public money shall be used in a prudent and responsible manner. Prudent and responsible way. And E, financial management shall be responsible and fiscal reporting shall be clear. So these are a provision that provides how public finances are to be dealt with. Okay? Then you come to procurement, Article 227, procurement of public goods and services. When a state organ or any public entity contracts for goods or services, it shall do so in accordance with a system that is fair, equitable, transparent, and cost-effective. So, you are telling the mover of the motion will be telling us that administrative action is enough deterrent to ensure that these articles of the Constitution are complied with. Nothing like that will happen. You've seen the major scandals. Let me just talk about the COVID one, the COVID millionaires.
Briefly, yeah.
So, here, a lot of COVID money is used, they were given to companies associated with various people. Do you think the companies associated with the big man was not involved? So, obviously, there will be no administrative action. The advantages that come with breaching the procurement are so huge that administrative action will be a slap in the wrist if at all it happens. So those provisions of the Constitution would remain unenforced if the amendments go through.
Okay, that's well noted, Murray. And we've definitely expounded on what exactly Kenyans need to know about these particular proposals and the far-reaching ramifications. As we finalize this discussion, because time is definitely on our side, definitely not on our side, I'd like to perhaps veer off those two proposals and talk about, in general, the fight against corruption. And Dr. Gikonyo, perhaps according to your analysis, and I don't know if this is a popular narrative in terms of, the wheel of justice grinds, but it grinds slow. In terms of prosecuting some of these high-profile cases around corruption, a lot of fingers have been pointed perhaps to the prosecuting bodies, to the judiciary, to those perhaps who are supposed to come up with the evidence. And we've had even judges mention that if you bring me, faulty evidence, the case will be dispensed off with and not in the way the prosecutor wanted as such. Talk to us about the fight against corruption and the timeliness around it, because as it is right now, cases of corruption and economic crimes are to be had on a day basis until they are finalized. So is this being followed from your analysis briefly?
My take on that issue is that there are still challenges. Mm-hmm. Without a doubt, we cannot ignore and say that everything is picture perfect. However, I wish to say that positive steps have been taken. The ESCC reports and shows, for example, how much they have recovered from prosecuting corruption cases. Just that those are never highlighted that much. It's just that the cases are taking forever in court, and that happens. It's not only in corruption cases, even in other cases within the judiciary. Yeah. But at the same time, positive steps are taking place, have happened, and are continuing. This discussion, for example, that we are having it, before we would not have had EACC, one of its members, as part of this panel. They are here to openly talk about what is going on, and to even acknowledge where the challenges are so that improvement can take place. Right. So, yes, challenges remain even in terms of the court process, but there are positive steps. There are even now more courts handling corruption matters, right? Not only at the magistrate court, you have now even at the High Court. All right. That is an improvement. Okay. But have we had much said about that?
Well, as members of the Fourth Estate, we'll definitely take it upon us to shout as much in terms of successes as much as failures. As we finalize, Murray, and your final comments right now, briefly, in terms of EACC, and you brought it up, the toothless watchdog has been used to refer to the Ethics and Anti-Corruption Commission, perhaps, highlighting some of the, issues around expectations by Kenyans in the fight against corruption. In terms of making the body more effective, what steps are being taken as we finalize briefly?
Well, the Commission is taking steps to improve its services. Okay. And to do that, it has to engage in innovation. It has to strategize, do things differently. Initially, we began with asset recovery, so doing very well. Out of that service of asset recovery, I got recognized by the President and given OEW, which I am really appreciative. So the focus has been asset recovery. We are also focusing on high-impact cases, involving high personalities, lots of money lost, matters of high public interest, so that perhaps when we focus more on high impact cases, perhaps the deterrence effect that it will have in future will be significant. The accusation that EACC just goes for small fish perhaps will disappear completely.
We're definitely changing the narrative right now. Yeah. So gentlemen and lady, thank you so much for your time. I know we've just hinted at the tip of the iceberg, so much to talk about when it comes to the fight against corruption, but we definitely appreciate you taking your time to break down what exactly these two proposals mean for the fight against corruption? Are they diluting or, strengthening the laws around anti-corruption right here in the country? I was joined by Dr. Constance Gikonyo, a senior lecturer at the University of Nairobi Faculty of Law, and Ben Murray, who's the Deputy Director, Legal Services at the Ethics and Anti-Corruption Commission. My name is Jesse Rogers. Enjoy the rest of your viewing. Ken Mujungu coming up next with a News Hour. Keep it KTN News.